If you're an international intended parent, you know that the end of your surrogacy journey is just packed with excitement, but also, a little bit of anxiety. So today, we're going to talk about a super important legal safety net, a plan B that every single international parent needs to know about for when life, inevitably gets in the way.
So let's just get right to the heart of it. What is that one nagging fear that's keeping intended parents up at night as that due date gets closer and closer?
It's this question right here. It's the most basic, most human worry for any parent to be. The thought of not being there for those very first moments, man, that is a heavy, heavy weight to carry. And look, this isn't just some abstract fear, right? This is the real world. Unexpected visa headaches, sudden travel bans, or hey, the baby just deciding to make an early debut, these are all very real things that could stop you from being in that delivery room. And this one problem creates this whole cascade of really specific, super stressful questions. Who's got the authority to approve standard medical care? How does the baby even get discharged from the hospital if you, the legal parents, aren't physically standing there? And then there's the biggest fear of all. What if the hospital has no choice but to call Child Protective Services because there's nobody with clear legal authority to care for your child? Okay, just take a deep breath. Because while those fears are totally valid, they are not a foregone conclusion. There is a proactive legal solution that's designed for this exact scenario. It's time to talk about your plan B. And what a relief it is to know that. If you can't be there, your newborn can still be safe, cared for, and completely protected under the law. The key, as always, is planning ahead. So let's look at the tool that makes all this possible. It's a limited power of attorney, or POA for short. Now, this is not about giving up your parental rights, not at all. It's a temporary legal document. It just empowers a trusted person, we call them your agent, to step in and care for your baby, but only until you can get there. All right, let's dive into this a little deeper. Because to really get the POA, you've got to see how it works together with another really critical document in the whole surrogacy process. So you have your pre-birth order, the PBO. That's the court order that officially establishes you as the legal parents. It defines who you are. The power of attorney, on the other hand, is a private document that defines who can act for you when you can't physically be there. So think of it like this. The PBO is about parentage. The POA is about presence. And that right there is the key takeaway. This is not an either-or thing. For complete, total protection, you absolutely need both of them. The PBO to establish your legal rights, and the POA to make sure your baby is cared for if you get held up. This leads to the next logical question, right? Who on earth can you entrust with such a massive responsibility? Who can be this agent? Generally, you've got three really good options. It could be a friend or a relative who already lives here in the U.S. It could also be someone you trust from back home, as long as they have a valid U.S. visa and are ready to travel at a moment's notice. Or, in many cases, your surrogacy agency might even be able to provide an experienced person from their team to step in. Now, this is a really, really critical point to remember. The person who carried your baby cannot also be the person who takes custody on your behalf. Hospitals see this as a huge conflict of interest. The surrogate's role is to relinquish her rights, not to take on a temporary parenting role. Okay, so we know what a POA is, but it's not just a simple permission slip. The details are what give this document its real power. So let's break down the specific authority it gives someone, why the state you're in matters so much, and what this whole thing costs. First up, and this is the most important one, medical authority. Your agent can talk directly with the doctors and nurses. They can approve routine things like the vitamin K shot, and crucially, they can authorize emergency care or NICU care if it's needed. They can also be the one to physically go in, hold, and feed your baby. Next is that mountain of paperwork that comes with a new baby. A well-written POA lets your agent sign the hospital discharge forms, apply for the birth certificate and social security number, and even get the ball rolling on passport applications. This administrative power is just absolutely essential to get things in order before you land. And finally, the actual logistics of care. The POA gives your agent the legal authority to take physical custody of your child from the hospital, get them to a safe place like a hotel or an Airbnb, and even get on a plane to bring your baby to you. Now, here's a detail that can make a world of difference. Geography. Not all states treat these documents the same way. POA-friendly states, like California, are really used to surrogacy, and hospitals there will almost always discharge a baby to an agent without batting an eye. But in POA-strict states, hospital policy might demand that at least one legal parent has to be physically there no matter what your power of attorney says.
And that makes a decision of where your surrogate delivers incredibly important, especially if you think there's any chance of a travel delay. It's a conversation you have to have with your agency before you're even matched with a surrogate.
So what's the price tag for all this protection and peace of mind? Well, it's actually remarkably affordable. You're looking at around $375 total. That usually covers the lawyer's fee to draft the document and the cost of notarizing it online. It's truly one of the most cost-effective insurance policies you can buy for this journey.
Okay, so we've covered the problem and we've covered the solution. Let's wrap this all up by turning this info into a clear, proactive action plan that puts you firmly in the driver's seat. Here's the timeline for your plan B. This whole conversation starts way back, before you even match, by talking about state laws. Then, around 32 weeks, you do a formal travel review to see what the risks look like. If there is any uncertainty at all, you get that POA drafted and notarized before the birth. And the best part? The moment you arrive and take that baby into your arms, the POA's job is done. It automatically becomes void. Let's just boil this down into 4 simple steps. 1. Be honest with yourself about your potential travel risks. 2. Talk to your agency about POA-friendly states and their specific policies. 3. Identify and confirm who your trusted agent will be. And 4. Get the document professionally drafted and notarized. It is so much better to have it and not need it than to need it and not have it. So, as we wrap up, it's really worth asking yourself this question. A successful surrogacy journey isn't just about planning for the best-case scenario. It's about being ready for the unexpected. By having the right legal tools in place, you can focus on the incredible joy that's coming, knowing your family is protected no matter what happens.